Lives there. Mr. Speaker.
Grant Robertson.
Mr. Speaker, John Key must stand down John Banks as a minister. The District Court in Auckland has called Mr. Banks to trial for knowingly filing a false electoral return. John Banks has lied to the Prime Minister, he has lied to the people of New Zealand, and he has filed a false return knowingly. No, he says, what about the trial? This is what the judge said, Dr. Smith. The judge said that John Banks had closed his eyes to the obvious. He had signed, Mr. Speaker, an electoral return that he knew was false. And why, Mr. Speaker? Because in the District Court yesterday, the Chief Executive of Sky City, Nigel Morrison, said...
A point of order, the Honourable Nick Smith.
Mr. Speaker, the Parliament, as the member has correctly observed, now has that this matter is going to trial before the courts. The court has made a decision that this matter is before the courts now. Now, there is a very clear standing order that members should not comment on matters before the courts so that it is seen to prejudice a fair trial for a member of this House. I think the member needs to be constrained given that crucial fact.
Yeah, I've kind of been, I think the word is internalising where this debate might actually be going. The first comment I would make is that a word which refers to terminological exactitude use has yet to be kind of proven, and I think the member should desist from that, right? The second point is the detail around what the court case might be, I would deem to be off limits, right? Because of the rulings that we have substantially had in this place about matters before the court. So I think the member shouldn't be referring in the detail of the case. Okay, I understand whether this is finely balanced argument. I'm trying to assist the member in trying to apply the rules of the House. Okay, Grant Robertson.
Speaking to the point of...
we'll extend.
Point of order.
Righto, thank you.
Mr. Speaker. I thank you for your advice on this matter. My understanding of the relevant rulings is that I am at liberty in this House to make comment on matters before the court. However, I do have to show the kind of judgment that I think that you've reflected. So I don't think I just want to make clear that I am not prevented from referring to those matters in my understanding of the Speaker's rulings.
That's a bit where I think I got to. That the members shouldn't try and deal with the detail of the case. So there's a matter which I think the member is referring to that relates to integrity, but in actually delving into the detail of the case. So I just caution the member on that part.
Mr. Speaker, and I want to quote from the public statement of the judge, and this is what he said. Mr. Banks has closed his eyes to the obvious. And what he is referring to there, in matters that have been dealt with many times in this House before, is that Mr. Banks signed an electoral return that he says he didn't read. And that was the excuse that he brought up in this House and in the public arena many times over the last year, that he didn't read it. Well, Mr. Speaker, that excuse is not available to a small business owner who's filing a tax return. They can't get away with it when IRD come knocking and say, oh, I'm sorry, my tax return was false because I didn't bother to read it. But that's what John Banks said. That's...
A point of order. Honourable Nick Smith.
Mr. Speaker, I want to refer you quite specifically to Speaker's rulings on matters that are to be adjudicated by the courts. They are very clear and they say, pending adjudication in the courts, they must
Can the member just refer me to the precise Speaker's
ruling? Yes, I'm referring to Speaker's ruling 31, 2, 3, 5 and 6 that quite specifically says that if a matter is pending adjudication in the courts, they must not be debated in the House. And what the member is directly proceeding to do is to debate just those issues.
I think the member has gone beyond what I ruled when you started quoting the matters which will be before the courts. now when he read the judgment and passing comment on that. I think you went beyond, and I was trying to assist the member. So I'd ask the member, in principle, yes, but detail, no.
Point of order, Mr. Speaker.
Point of order.
I want to clarify with you that the judge of the court has, in the High Court, in the District Court, has issued a ruling today. I must be at liberty to be able to quote from that.
You can, but not comment on it.
Yeah, right, that's right. How long do I have left, Mr. Speaker?
Just over 3 minutes.
Mr. Speaker, the judge today has said not only did Mr. Banks close his eyes to the obvious, he's also said this, that the evidence shows an apparent
a point of order, Nick Smith.
Mr. Speaker, the decision by the court today is that Mr. John Banks will stand trial on these issues. That's all. So what we know from the court is they've said there is sufficient evidence for this to go to trial. Now, I do not think the opposition Leader of the House can proceed down the road that he is going relative to the standing orders that are just so clear in this area. If a matter is to come up before the courts, this Parliament should not debate it because it's prejudicing the proper trial that the court must have.
Speaking to the Board of Order, Grant Robertson.
Mr. Speaker, Dr. Smith says that all the judge did was say that the matter should go to trial. That's not correct. The judge made a number of comments today which are in the public arena and which I am entitled to refer to.
Yeah, look, I'm taking my advice from 30 point number 3 on page 30, which is why I've ruled the member can quote but not comment on. And if you look at 33, the law in a general way may be discussed but may not discuss the application. So I've just, and that's where I've taken, and I've said the member may quote but not comment on. So the judge's determination that the member is quoting is in the public arena. And I've said the member is at liberty to quote that but not comment on. That's the ruling I have given.
Mr. Speaker.
Grant Robertson.
Mr. Speaker, what the judge has said is that the evidence in the case shows an apparent intention to treat as anonymous the donation given by Kim.com. That donation was a donation that Mr. Banks met with Kim.com to discuss.
Honourable Nick Smith.
Mr. Speaker, the member immediately ignored your ruling. He was quite entitled, as you said, to simply quote what the court said. The moment he finished that, he then went on to a commentary of the evidence, and specifically with respect to Mr. Kim.com. The member cannot litigate. The standing orders and the Speaker's ruling are very clear that the member cannot litigate the matters that are now to stand trial with Mr. John Banks.
Point of order, Mr. Speaker.
Speaking to the point of order, or?
Yes, indeed. Thank you,
right.
sir.
Honourable Clayton Cotsworth.
Thank you. There is one point that Mr. Smith failed to make, and that he cannot litigate your ruling. And he is not the Speaker. You are the Speaker. You determine what is an order, not him.
I don't actually need to be reminded of that. Can I firstly say that I was distracted while the member was speaking, so I'm sorry that I wasn't able to do that, but I was doing some research on the matter. And this is actually a matter of balance. And I think that the question that the member is raising pertains to a member's relevance in this House. That I understand. But I've been very clear that the member cannot litigate, comment on the judge's ruling. Now, the difficulty I also have is that I don't actually have in front of me the judge's ruling to know where the member is quoting and maybe adding to. So I'm taking the member, I'm cautioning the member to very clearly understand what I'm saying, and I will listen with greater attention now. The member has 2 3/4 minutes.
Mr. Speaker, John Banks has consistently said in the public arena that he did not know.
Point of order, Mr. Speaker.
Point of order.
Mr. Speaker, I want to directly read the standing order. Standing order 1112 says this. Matters awaiting any New Zealand court may not be referred to in any debate.
That's right.
May not be referred to in any debate. Now, the immediate point the member went into was a debate specifically about what John Banks had said publicly on the very matter that is now going to stand trial in Auckland. And it is not appropriate. It is not appropriate for this Parliament to assert the right that the court now has to resolve this issue.
That's right.
To the point of order, Grant Robertson.
Mr Speaker, I had only got out about half a sentence on that occasion before Dr Smith stood up. I hadn't mentioned anything about the court at that point at all. What I was about to refer to, Mr Speaker, was statements that John Banks has made in public that are relating to his campaign for the Auckland mayoralty, and I was going to go on to talk about statements John Key had made about whether or not ministers lying would constitute whether or not he should keep them on as ministers. Dr Smith didn't even give me the chance to get to that point. I've listened to your ruling and I'm going to speak in accordance with it.
I'll read again Standing Order 1112, which is pertinent to legislation. And that's my interpretation on that. The matters awaiting or under adjudication or in any suppressed by an order of any New Zealand court may not be referred to in any motion, debate or question, including supplementary questions, subject always to the discretion of the Speaker. And the right to legislate.
What the standing order is saying is that this requirement not to debate issues does not prevent the Parliament from being able to get on past law. And I agree with that.
Yeah.
But can the member debate the very matters before the court that will be subject to the court ruling today? And the answer is very clear from that standing order that we must let the High Court do its job and make the judgment as to whether Mr Banks broke the law or not.
And that's why I've said the member can go as far as quoting but not debating. That's why I said now let's see if we can make some progress.
And where are we at now?
2.5 minutes.
Very good. Mr Speaker, John Key came into this office of Prime Minister saying that he would hold his ministers to the highest ethical standards. He also came to this Parliament and he said he would stand a minister down if that minister lied to him. They are the standards that John Key has set. And Mr Speaker, those standards have been broken by John Banks. This is a shoddy, tawdry government propped up by a Member of Parliament who has consistently misled New Zealanders, whose memory is such he can't remember getting in a helicopter, flying to the Coatesville mansion, having lunch with Kim.com and a woman he described as the most attractive woman in New Zealand at the time. He can't remember that. He can't remember asking for a $50,000 donation to be split into two. He can't remember getting a donation passed across the table from Sky City.
Point of order.
The member,
Nick Smith. Order!
The member is immediately breaching your ruling by getting straight back into the debate of the very issue that is going to stand trial. And I think you need to stand to the standards of the House, long established, that you cannot debate a matter before the courts, of which this quite clearly is.
What's been the point of order, Mr Speaker?
Honourable Clayton Cosgrove.
Thank you, Mr Speaker. I did make a point before, and you may have, I meant no offence, you may have misinterpreted. I was actually trying to defend your position. Sir, that member needs to read standing order. You are the sole judge.
Order,
and it's
order.
for you to call a member to account.
Order. Thank you very much. Look, I'm trying to steer a course of balance here and uphold the standing orders, and I've made it clear that the member can refer to but not comment on, and I think the member was getting into that order. He was fine till he got to some of the detail around that, so I'll just give him 1 minute 20.
Point of order, Mr Speaker.
Point of order, Grant Robertson.
Mr Speaker, the case that is before the District Court is around the question of whether or not Mr Banks has knowingly filed a false electoral return. In the period that I was speaking before Dr. Smith interrupted me again, I was speaking about a set of facts that are actually not relevant to whether or not a return was filed. Whether Mr. Banks has forgotten that he flown in a helicopter to the Coatesville mansion is not a matter that is currently before the court. So knowing that, I will carry on with how long left, Mr. Speaker?
Just over a minute.
Just over a minute. Mr. Speaker, this government relies on John Banks' vote to pass critical legislation such as the legislation implementing the Sky City deal. That's what stands between the government and passing its law, and that's why they have such a desire to protect John Banks. Nick Smith spent about 20 minutes trying to protect John Banks. He's doing that because this government knows that it is only standing on the record of a man who will stand trial for electoral fraud. John Banks should not be a minister because John Key should have stood him down when the police report came on about this last year. But John Key wouldn't even read the police report. He closed his eyes because he didn't want to know the truth. Now, Mr. Speaker, he will have to face up to the truth. John Banks will stand trial for electoral fraud. This government will stand on the basis of that tawdry, shoddy behaviour. John Key must stand John Banks down.
Mr. Speaker.
Gareth Hughes.
Kia ora, Mr. Speaker. Ngā mihi nui kia koutou kia ora. We've seen some gripping television on our screens this week, Mr. Speaker. We've seen the Koharanganau credit card scandal.